Hello, my name is David Winch and I'm a chartered accountant with Bartfields Forensic Accountants. Today we are going to be talking about revisits under Section 22 of the Proceeds of Crime Act 2002. And it is a topic which can be a little bit controversial. So let's have a look at the agenda. We'll talk briefly about a typical prosecution application, then go into what Section 22 actually requires, talk about the court's discretion under Section 22, because unlike when a confiscation order is first made, when a confiscation order is varied under Section 22, the court does have discretion. And then, although Section 22 is officially about reconsideration of available amount, we'll talk about the role that benefit plays in a Section 22 revisit, and we'll round off with a little bit about how Bartfields can help you. So the typical situation, well, typically a defendant has been made subject to a confiscation order, perhaps some years ago, could be even up to 10, 15 years ago. But we're talking here about a confiscation order under the Proceeds of Crime Act 2002. We're not talking about a confiscation order under the Criminal Justice Act of 1988. That confiscation order showed the defendant to have a benefit which was at the time in excess of his available amount. And so he was ordered to pay the available amount that he had at the time. Coming forward to today, the defendant currently does have assets, and the prosecutor has made an application to the court seeking a further payment under the confiscation order, which is a variation of the confiscation order under Section 22. Now, prosecutors often approach Section 22 applications as if what we have on this slide is enough. It's all we need in order to make a successful Section 22 application to require a further payment from the defendant. But as we will see in a minute, that's not the situation. Under Section 22, what we're doing is reconsidering the defendant's available amount. And in doing that, the prosecutor can bring before the court evidence relating to events before or since the confiscation order was made. There are other ways in which confiscation orders can be varied. For example, the benefit can be varied under Section 21. That only involves consideration, or broadly speaking, only involves consideration of events before the confiscation order was made. Section 22 doesn't work that way. Evidence relating to events right up to now can be relevant. And Section 9, which is the section in POCA that deals with available amount, is applied, but with certain modifications, as we will see. Section 22 says if a trigger condition, as I've called it, is satisfied, the court on reconsideration has discretion to vary the amount required to be paid under the existing order. So we're not here making a new confiscation order. We are varying an existing confiscation order, and it's useful to bear that in mind. So when we're doing this variation, sections 6, 7, 8, 10, and 16 to 18 do not apply. Section 6 is the section about making a confiscation order. Section 7 talks about realizable amount. Section 8 talks about where there's been a previous confiscation order. Section 10, criminal lifestyle assumptions. Since we're not dealing with benefit here, we're not applying the criminal lifestyle assumptions anew. Sections 16 to 18 are the sections that deal with statements. Section 18 is requiring the defendant to produce information to the court. Section 16 is, as we know, the prosecutor's statement when he's applying to have a confiscation order made. Section 17 is the response to that from the defendant. Those sections don't apply under Section 22. So let's look at a typical prosecution application. we will have perhaps a witness statement, usually a witness statement from an accredited financial investigator or similar, which identifies new assets or increased asset values. It will generally include a summary of the original confiscation order and any later variations that have previously been made. And it'll provide information on any current restraint order. It will then typically specify a new figure for what's described as the defendant's aggregate available amount and a table of default sentences. So it has some similarities to the Section 16 statement, but the Section 16 statement, of course, has a lot more in it than we would see in a Section 22 application. So a typical prosecution application, is that what the court needs? Well, I would say that that typical prosecution application fails to correctly perform what's called the new calculation in Section 22. Section 22, subsection 3 refers to a new calculation. Fails to establish the relevant amount, which is specified in subsection 8 of Section 22. Sometimes fails also, or usually fails also, to address changes in the value of money, which is required under subsection 7. And that's particularly important because we can be dealing with a long period of time with the Section 22 application. I have never seen a Section 22 application which actually correctly considers whether the trigger condition in subsection 4 has been satisfied. And in my view, at least, that's absolutely vital to the court in Section 22 applications. Also, as we'll mention later, we are going to want to review the original benefit in relation to what may be just. And I'll say more about that a bit later on. And we need to consider the implications of Section 39 with regard to default sentence. Now, those of you familiar with confiscation may still not be terribly familiar with Section 39. Section 35 is the one that specifies what the default sentence can be when a confiscation order is made. But we are not here making a confiscation order, we are varying an existing confiscation order. And because of that, Section 39 is the relevant section when we're considering the default sentence in a Section 22 application. And as we'll see, Section 39 differs in important respects from Section 35. Also, the prosecutor tends to confuse or conflate the result of the new calculation under Section 22, subsection 3, which is the defendant's available amount today, with the proposed revised amount required to be paid under the confiscation order. Now, the amount revised, the varied amount required to be paid is the total of the amount that was required to be paid previously and the additional amount which is now required to be paid. Prosecutors tend to describe that aggregate figure as the defendant's available amount. In my view, at least, that is not the defendant's available amount. That is the aggregate required to be paid under the confiscation order. So describing it as the available amount risks a misunderstanding of what Section 22 requires. Certainly that figure is not the result of the new calculation under subsection 3. So what does subsection 3 say? Well, it says, in a case where this section applies, Section 22, the court must make the new calculation. And in doing so, it must apply Section 9. But as if references to the time when the confiscation order is made were to the time of the new calculation. So what does Section 9 say? Well, Section 9, subsection 1 says, for the purposes of deciding the recoverable amount, the available amount is the aggregate of the total of the values at the time the confiscation order is made of all the free property then held by the defendant, minus the total amount payable in pursuance of obligations which then have priority, which is things like fines and so on, plus the total of the values at that time of all tainted gifts. So that's what we're doing when we're making, under section 6, when we're making a new confiscation order. That's how we calculate the available amount. So what does section 22 do to that? Well, because of subsection 3, that wording in effect becomes this. For the purposes of deciding the recoverable amount, the available amount is the aggregate of the total of the values at the time of the new calculation of all the free property then held by the defendant. Note, then held, as in now, at the time of the new calculation. So we're looking at the total of the values today of all the free property held by the defendant today, minus the total amount payable today in pursuance of obligations which have priority, and the total value today of all tainted gifts. So in terms of tainted gifts, we might be looking back over a period of, say, 20 years for tainted gifts, because if we imagine that a defendant has had a confiscation order made against him, let's say in 2010, and at that time there was a suggestion of tainted gifts, and so the relevant day will be worked out, and that might have been back as far as 2004. If we're doing a reconsideration today, in terms of tainted gifts, we're looking at the period from 2004, the relevant day, right up to today, and looking at all those tainted gifts made by the defendant, if there are any, and adding them in to our calculation of the available amount today. Okay, so there's a trap there for you with tainted gifts. But the crucial thing is that under section 22(3), we need to calculate the available, excuse me, the available amount today. And then section 22 unless you've previously done a section 22 revision, in which case it's the latest available amount that you found. And section 22(7) says, in deciding under this section whether one amount exceeds another, the court must take account of any change in the value of money. That again, usually overlooked by prosecutors. So what does section 22 require? What does all this come to when we put it all together? Well, step one is we have to identify the relevant amount. This is the logical method of doing it, rather than going through the subsections in order. First, identify the relevant amount under subsection 8, and that's the previous available amount. So in most cases where there's not been a variation previously under section 22, you simply dig out the confiscation order, look at the available amount that was decided when the confiscation order was made, and that's the relevant amount under subsection 8. Then you have to uplift that for changes in the value of money since the confiscation order was made, and you use CPIH for that. And then the court makes a calculation of the defendant's available amount today under subsection 3, applying the rules of section 9 to the situation today, and that's what we've just discussed. Interestingly, there isn't a burden of proof here on the defendant to show what his available amount is. So that's a different situation from when you're making a confiscation order originally. In practice, of course, the prosecution will be putting forward their ideas as to what the defendant's available amount is. Then the court has to determine whether the defendant's available amount today exceeds the uplifted relevant amount uplifted for changes in the value of money. If it does not, the court has no opportunity to vary the confiscation order under section 22. If it does, the court may vary the confiscation order by substituting a new amount required to be paid. So the question the court is asking itself, if you like, or section 22 is requiring the court to ask itself is, does the defendant's available amount today exceed the available amount we found when the confiscation order was made, adjusted for changes in the value of money? If it does not, that's the end. The new amount required to be paid must not exceed the defendant's benefit. But again, we're comparing two figures, and so we have to uplift for changes in the value of money since the benefit was determined. And the benefit is either the benefit per the original confiscation order, or where that's been previously varied under section 21, the varied benefit found under section 21. If the court does vary this confiscation order by substituting a new amount required to be paid, it should substitute such amount as it believes is just. Now, notice here that the court is not required to decide based on the defendant's available amount. The defendant's available amount today is relevant to the question of can the court vary the order or not, but once the court has passed that hurdle and found that it can vary the order, then the available amount isn't necessarily anything to do with the amount that the court believes is just. That's a separate exercise. In reaching its decision, the court must have regard in particular to certain matters listed in subsection 5 and subject to subsection 6. I'm not going to go into the detail of that today because we would run well over our time if we did. But you can have a look at the statute. It's fairly straightforward. And the default sentence. Well, where an order is varied under section 22 and the effect of the variation is to vary the maximum period applicable in relation to the order under that new table, I say new, it's been in since 2015, in section 35, then the court may amend the term of imprisonment or detention fixed in respect of the confiscation order. Note the flip side of that coin. If you're in the same bracket still, the court cannot amend the default sentence. So suppose somebody originally had an available amount of £15,000 some years ago, and a default sentence was set based on £15,000. Fair enough. Today, that defendant has received a legacy. He's now got £450,000. And that's his available amount today. And the court's going to vary the order to require him to pay a further £450,000. All well and good, but it can't change the default sentence. Why can't it change the default sentence? Because we're still in the same bracket. That bracket, if you remember, runs from £10,000 to £500,000. So we're still in the same bracket, so the court does not here have an opportunity to change the default sentence. It's a bit of an odd provision, bit of an odd way of doing things, but that's the law. I didn't write the law, that's what POCA says. Incidentally, section 39 has been amended with effect from the 1st of December 2020 to refer to the table in section 35, which I've got on this slide. So that's an amendment that's just recently been made to clear up as something of an anomaly between section 39 and section 35 that existed before. Right, let's quickly look at some case law. Case of Cole. The Court of Appeal said the questions that then arose under section 22(4)(a) were, 1, whether the new calculation of the available amount exceeded the previous calculation of available amount, which it did in Mr. Cole's case. And it then went on to consider what variation should be made under section 22. Useful cases, Padder, where in terms of the court's discretion, the Court of Appeals said it is entirely appropriate for a court to consider such matters as the amount outstanding, the additional amount which might now be available for further payment, the length of time since the original confiscation order was made, the impact on the defendant of any further payment contemplated, and indeed any other consideration which might properly be thought to affect the justice of the case. Because, as we've said, the court is making the variation to the amount which it deems is just. What do we mean by just? Well, the word just means just in all the circumstances, bearing in mind that the purpose of such orders is the advancement of the public interest in confiscating the proceeds of crime. That's a case of Monday. And also in that case, the sums involved actually were modest, and the judge basically in the Crown Court, the judge just threw it out, said, I'm not going to do it. And Court of Appeal said judges are entitled summarily to dismiss applications which they regard as being substantially without merit. We have concluded that it was open to the judge on the material before him to decline to vary the order. So this defendant did have a few more assets. He had a van, he had a bit of this and a bit of that he hadn't had previously. Prosecutor made an application under Section 22. The Crown Court judge said, nah, don't fancy that. Change of law. Cole was a case involving mortgage fraud. In the Crown Court, the judge said, well, since Mr. Cole's confiscation order was made, we've had the case of Weyer. Weyer has changed the way in which benefit is calculated in mortgage fraud cases. But in the Crown Court, the judge said, but I'm just not going to take account of that because I think it's fair that he should have to pay based on the original confiscation order. Original benefit in the original confiscation order. Court of Appeal didn't like that. They said once it is accepted that the benefit figure in this type of case falls to be calculated in accordance with the decision in Weyer, the court should not have proceeded under Section 22 as if Weyer had not been decided. So in other words, it was just to look again at Mr. Cole's benefit in the light of the law as we understand it today and say, right, well, if this were a confiscation order being made today, we wouldn't have found that to be benefit. We wouldn't have required him to pay it. So it's not just to require him to pay it today. And where, of course, dealt with proportionality. The amount required to be paid should not be disproportionate, but a just order should not be disproportionate in any event. Case of Ahmad, again, you'll be very familiar with this, where there's a finding of joint obtaining, the confiscation order should provide that it's not to be enforced to the extent that a sum has been recovered by way of satisfaction of another confiscation order made in relation to the same joint benefit. Section 22 does leave some questions in the air. Time to pay. Section 11 is the one that says where a confiscation order is made, there's 3 months to pay and there can be an application for a further 3 months. We're all very familiar with that. What about where a confiscation order is varied under Section 22? Does Section 11 apply? And if Section 11 doesn't apply, what are the rules in relation to when a confiscation order, when a variation in a confiscation order, when that's required to be paid? And running on from that, what about interest? Interest under Section 12, I'm sorry, runs from the date payment is required. But if we don't know the date when payment is required, then we don't know when the interest starts running from. Now, in practice, what courts have done is simply assumed that Section 11 and Section 12 apply on a variation under Section 22 in the same way that they apply on the making of an original confiscation order. Interestingly enough, that assumption is not made where there's a variation under Section 23, but Section 23 and Section 22 are very similar in lots of ways. And the default sentence. I mentioned somebody had a an available amount of 15,000. He's got a new available amount of 450,000. Presumably, the confiscation order is going to be amended so that he's required to pay 465,000, of which 15,000 has already been paid. So he needs to pay a further 450,000. Presumably, the default sentence is going to be based on that figure of 465,000. And as he's paid £15,000, if his default sentence was, say, 9 months, that was fixed when it was £15,000, right, he's now got a default sentence of 9 months in relation to £465,000. He's paid 465ths of it. Is that how we calculate the reduction for part payment? What about if we have a Section 23 application after a Section 22 application? And indeed, what about if we had a Section 23 application prior to Section 22 application? Because in defining the relevant amount, Section 22 said, didn't it? It's the available amount per the original confiscation order, unless that's been varied under Section 22. What about if the available amount has been varied under Section 23? Do we take account of that in doing our Section 22 computations? Or is the relevant amount decided ignoring that Section 23 variation? All these sort of issues are rather left unclear by the legislation. Right, so as I've said before, and I will no doubt be saying again in the new year, Bartfields Forensic Accountants remains fully staffed. We undertake legal aided and privately funded criminal and civil forensic accountancy work. Even in the pandemic, it's relatively easy for us to conduct the bulk of our work remotely using our up-to-date and secure IT facilities. And we remain readily contactable by phone, email, and online video links, Zoom and Microsoft Teams and so on. Our recently updated website is full of useful information and, of course, accessible 24/7. And you can find more on this topic and others on the website in the news section, and this and previous webinars can be found in the seminars section of the website. The links are there on the screen for you. We'll be sending you a free recording of this webinar. And if you've any questions, the easiest way to get hold of me with technical questions is to email me. My email address is there on the screen. Drop me an email, I will reply and help you as much as I possibly can. Thank you very much for your time. I'm sorry we rushed through it, but there was a lot to get through, and I did want to keep to the original 30-minute that we advertised. So thank you for your time. I'll see you in the new year. Thank you. Bye.